for the LLC form. And then we would become, let's say, directors, officers, and shareholders of this new corporation. Have our fiduciary duties changed? That's the question. The Supreme Court of Kentucky has repeatedly said that the common law, all of the artificial entity law is built on top of a common law foundation. It's not necessarily displaced because you change forms of doing business. So that's the basic point. So what do you think? Do you think that he and I would continue to be fiduciaries of each other so long as we continue to repose mutual trust and confidence in each other? That's what the common law says. Or is our relationship fundamentally changed because we changed the type of entity that our business falls within? We changed our legal form of doing business, but we didn't change our personal relationship. Now, if we sat down and drawing up an operator and said, you know what, we trust each other for so long, now let's not trust each other anymore. Let's cogently sign away and create a new sort of relationship. Maybe that would change it if you changed it contractually and actually had knowledge that that contractual relationship was being reestablished in a different form. I think otherwise, so Elizabeth and I are taking a position which I think is solid law. Case law supports it, that regardless of what form our business takes, as long as he and I have our special contextual relationship, that it's going to stay fiduciary. And if we bring in 6 new shareholders, at some point our relationship may stay the same, but we don't have that relationship with those 6. They're going to have to look for other sources of any special relationship among them. So that's basically what this article is about. We're putting the finishing touches on it, and it should be published in the UL Law Review shortly. But I just wanted to share that with you. It's foundational. And sometimes it's fun to write a foundational article as opposed to something where you're really arguing normally arguing what should be. In this case, we're simply describing what we think is, but we couldn't find any Kentucky cases squarely in point. There was no Kentucky case rejecting what we're saying. And note how this differs from the fiduciary duty among shareholders in closely held corporations. If Kentucky were to adopt the Donahue case, for example, out of Massachusetts, then shareholders in closely held companies would be fiduciaries that have the fiduciary status. Context wouldn't matter. So they have fiduciary status. But we're not pushing for that. We're saying that contextual fiduciary relationships should continue if they are in fact fiducial in character. That's the whole squad. I thought it was pretty interesting, Sherry, especially given the topic that we're about to address. So with that,
thank you. So for a little bit of context on that, my presentation is from the point of view of the Donahue Standards, so just so everybody has the same point of reference to work from. So there's that fiduciary. So my name is Ethan. I'm going to talk to you guys today about potentially conflicting fiduciary duties among closely held corporations, with a specific emphasis on. So there are 4 main topics I'm going to cover. First, I'm going to talk about a specific problem in succession planning, which, as we all know, is the natural progression of business from one person to another. I'm going to talk about fiduciary duties as they relate to specific roles, and I'm going to address issues of when one person acts in 2 fiduciary capacities. Lastly, I'm going to talk about when that person who acts in those 2 capacities has conflicting duties. So this is a problem that I'm going to use for everybody to sort of frame my discussion so that we're all aware. I know it's a lot easier to contextualize things whenever we're able to have something to look at and think about while I'm giving this talk. So if you guys don't care, just take a few minutes and read through this problem, and as we go through, try to keep it in the back of your mind. So under this situation, we have to think about a few things. First, what fiduciaries does Sonny owe to his brother, Kiddo, as the trustee? What fiduciary duties does Sonny owe to the company and the shareholders? And lastly, what is the result whenever those 2 relationships conflict with one another? The situation, I'll go back. The situation in which this kind of conflict occurs is one that most people, the patriarch or matriarch of family business, find themselves in whenever they have several children that they would like to receive the benefit financially of the business. So the uninvolved child tends to be at the mercy of a sibling who has significant opportunity to exploit their position of power as a fiduciary, all the while being protected by sometimes imprecise or lax fiduciary standards of conduct. So the child in charge of the business, if the child wants to discharge their fiduciary duties fairly, faces a very complex dilemma. That child has to act as both the fiduciary to the corporation, running the corporation in the best interest of all stakeholders, and they have to act as a trustee to the sibling, owing an undivided loyalty to that specific shareholder. So, we all know family businesses are the backbone of the American economy, but they also struggle with succession planning. And this legal uncertainty is a significant threat to the business's survival, and an analysis of these questions would be really advantageous to understanding what business succession planning is, but it can also continue scholarly debate regarding the evolution of fiduciary duties in the trust and business entity context. So, as we all remember from business works, the essence of a fiduciary relationship is one that's open-ended, and where that one person exercises control over the property owned by another person, or some discretionary power of one person over another. So the fiduciary has been entrusted with this power, and they've been given some level of unsupervised discretion, and also the label of fiduciary. So once this label of fiduciary attaches, the person entrusted with the power has the duty to act unselfishly, and breaches of this duty tend to be punished, sometimes more or less, than a breach of contract. The extent of the unselfishness with which the fiduciary has to act depends on the specific relationship that they have with the other party. The more power the fiduciary has, and the less power control the beneficiary has, the higher the duties. The greater the independent authority to be exercised by the fiduciary, the greater the scope of his fiduciary duty. So, at the top of this relationship, if we think about fiduciaries generally, not necessarily one who has a fiduciary duty to a corporation, is the trustee. Because a trustee has this stricter duty of loyalty than an agent upon who otherwise limited duty would be conferred. The trustee has almost complete control over the trust, so what the beneficiary will receive. So as we all know, and as Kentucky statute reflects, there are 2 main elements to fiduciary duties: the duty of care, the duty of loyalty, and there's a third one which states that it's a good faith requirement, which I'll talk about later. But the duty of care is the duty to perform competently and includes the duty to carry out the fiduciary purpose. So they have to be prudent in their actions, they have to protect the property entrusted to them in their fiduciary capacity, they have to not commingle the fiduciary's assets with their own, they have to invest prudently and properly, which may include a duty to diversify, they have to account to the beneficiaries, and they have to be impartial in the treatment of persons who hold an interest in the property. The duty of loyalty is the duty of unselfishness. It's the duty to refrain from exploiting a relationship for personal gain and to refrain from taking any benefit from the relationship other than reasonable compensation. So, as I mentioned, the trustee is the most vertical of this relationship because the beneficiary has no control. The beneficiary is restricted to monitoring the trustee's actions, and they have very limited ability to exit the fiduciary relationship. So there are also no monitoring mechanisms in place to protect the beneficiary of a trust. Courts don't really give any scrutiny to what a trustee does until they've done something worthily wrong. So how do we describe this gold standard of a trustee's fiduciary duty? The duty under common law prohibits self-dealing, except when the settlor of the trust authorized the transaction or all of the beneficiaries consented after full disclosure. Self-dealing includes not only transactions between the trust and the trustee, but it could also include those transactions between the trust and an alter ego of the trustee, such as a straw man, close relative, or closely held corporation. So whether the relationship between the trustee and third party to the transaction is close enough to trigger the self-dealing rules is usually a question of fact. The hallmark of the trustee's duty of care is to minimize risk. The trustee must accept only that level of overall risk that's appropriate in light of the circumstances. The trustee's duty of care has been phrased as one that is of caution. As stated in the comments of the Uniform Prudent Investor Act, a trustee's main purpose is to support an elderly widow of modest means will have a lower risk tolerance than a trust to accumulate for a young son of great wealth. So this duty of care includes the duty to delegate responsibility, which originally was not the duty to delegate, but when by necessity evolved into the duty to delegate, so long as the trustee used reasonable care, skill, and caution in selecting and making monitoring actions. This duty of care can generally be relaxed by the trust instrument, but that cannot be eliminated. Well, the fundamental requirement that trustees behave recklessly but act in good faith with some suitable degree of care and in a manner consistent with the terms and purpose of the trust. As long as it's consistent with those terms, that duty alone can't be eliminated, but most others can. In a corporate setting, the board of directors and the corporate officers are fiduciary for the corporation. The duty of care is particularly weakened in a corporate setting. A typical statement of the duty of care is a duty of the corporation to perform the director's or officer's function in good faith, in a manner that he or she reasonably believes in the best interest of the corporation, and with care that an ordinary prudent person would reasonably be expected to exercise in a like position under similar circumstances. So this, we all know, is the business judgment rule. The business judgment rule sometimes can leave a court wondering whether or not they've done enough to hold the fiduciary responsible for their actions. But a court may not want to elect to hold the fiduciary responsible under the much more stringent trustee fiduciary duty. Several courts have wrestled with this issue, and as courts in different states have taken varied approaches, even whenever they are evaluating the trustee director's conduct. In Rosencrantz versus Fry, defendant trustee sought authority to sell himself shares of stock to which he had been given an option to purchase pursuant to testator's will. Plaintiff beneficiary filed a complaint seeking to restrain the defendant's sale and purchase of the shares. The court held that the defendant was entitled to receive the shares of stock, and that the trust was entitled to receive the money generated by the sale of stock. The court further held that there was no basis in the record to find that the defendant had breached his duty as a trustee by omitting to declare a dividend prior to exercising his option to buy. So, under this situation, the court said what we would normally consider as kind of a weird place for a fiduciary to exercise their discretion, because they had the option under the will to purchase the shares, and even though they are dealing with the trust itself, we're going to allow it because it was contemplated under the will itself. Right? So, as I mentioned before, testators have huge latitude in picking and choosing who their fiduciaries are, and in a succession plan, that's incredibly important whenever they're making a decision about to whom to leave their business, because they've generated all this goodwill for years, and they're also considering their second child, who would benefit from the business doing well as a beneficiary to the trust. So there are a lot of factors in play and really strange interplay of those fiduciary duties. New York, in contrast, has taken a very clear stance. So they have definitively held that the trustee level fiduciary is the one that prevails. So not the lower business judgment standard, but the much higher fiduciary duty of trustee. They said that where a trustee holds working control of stock in an owned corporation, he is accountable in the probate court for the administration of corporate affairs. Okay? So the court recognized that the executor or trustee may not use the corporate character as a shield to protect himself from, or censure from, where the fiduciaries control the corporation by help of an estate. So New York's court held that the duty of trustees as personal representatives, they have to maintain that high secret. The Georgia Supreme Court has a much more nuanced understanding of the duty of fiduciary whenever they hold both the title of director of a corporation and also trustee. They said that the trustee level fiduciary standard, which the lower court had based on that New York case I discussed earlier, they said that wasn't going to work. They said it may be appropriate as a general rule, but because of, as the facts that we have in our hypothetical, there are much more difficult questions about to whom the duty is owed and which one makes the most sense in a business setting. So they recognize that trustee managers are generally subject to that trust level fiduciary standard, the high one. Under the facts of the Rollins case, the court found that the corporate level, so the business judgment rule, was the one that was more appropriate to evaluate the trustee's conduct as director of the corporation. Several other courts have considered this, New Jersey and Ohio. But overall, the courts take a series of factors into deciding whether or not to apply that lower level of review or that higher level of review. First is the claimant's interest of minority. So kiddo's interest in this instance, 20% or 40%, right? So that means Sonny and the other minority shareholders make up the majority. The next question is whether or not the testator considered the dual relationship and whether they considered which relationship they considered to be more important. Is it more important that Sonny do what's best for the business so that kiddo can benefit from that, or is it more important that Sonny look out for kiddo's interest over the business? Lastly, the courts will consider which duty was most harmed by a particular course of action. So if the testator had that intent and the director trustee makes the decision, well, in this instance, it's way more important for me to protect kiddo's interest in this corporation, even if the corporation will be greatly harmed. Right? That's whenever the court may decide, well, we'll apply the lower standard. A key question from all this is whether or not the trustee director's conduct should take the needs of the beneficiary into account. Courts are constantly wrestling with this question. So, for example, if the beneficiary of the trust is elderly and the trust is their primary source of income, that would seem to dictate that the trustee business manager needs to avoid risk, such as expansion or development, that would put a strain on the business's finances. This conflict is similar to that of a trustee's conflict between serving an income beneficiary or a remainder beneficiary. And trust law, in particular, has responded by imposing a duty of impartiality. Now, this duty of impartiality requires that the trustee straddle the interest of the two, and not favor one over the other. So, in the scenario that I just proposed, the trustee business director would have to consider both the interest of the business and the interest of the elderly beneficiary. So, this impartiality approach may be too modest, right? Because it doesn't really allow the trustee business director the flexibility that he or she needs to make decisions because of that impartial relationship. So, the duty of care owed by the fiduciary may be an issue that's easier for us to tackle. The risk-taking necessary to run a business and the ability to be free from the requirement of diversifying risk, they both face constraints from the trustee's duty of care. A trustor, the person who is writing the trust, raising the trust, they have significant power to reduce that duty of care, as long as the trustee still acts in good faith. This power of the trustor, together with the implication that the trustor intended to reduce the duty of care, should be enough to create a presumption that the dual role should be lesser to the corporate duty. This is trust rule. Right? That's my proposal. So, in turn, your petitioner, plaintiff, the person to whom the duty is owed, could rebut that presumption by statements of contrary intent of the trustor at the time they were alive. So this would give us enough leeway and flexibility, as opposed to the duty of impartiality under this review, for the fiduciary to make decisions about their duty of care and how to best exercise that. There are problems with this kind of approach. Dropping the duty down from the highest to that under the business judgment would disregard the beneficiary status in way more sensitive contexts, right? So, of course, that stricter rule is far too limiting and doesn't allow the business director to take risks that are often associated with the enterprise. So, as I said a minute ago, the duty should be somewhere in between. The court should explicitly recognize that the position of the fiduciary to the business entity requires the fiduciary to balance the best interest of both. They have to weigh what the interest of, in this dual role, they have to weigh what the interest of the business and corporation is against the interest of the trust, the beneficiary of the trust, and they have to make a decision about which one is going to cause less harm. Now, whenever we're talking about a derivative action here, which is what will be brought whenever a fiduciary violates their duty, the court should not second guess that business determination that they make under those circumstances, right? So, and like I said, guys, this is a really complicated area of the law, and as Professor Warren mentioned, Kentucky doesn't have a whole lot of case law on this issue, so we have to look to other places to be instructive. So, this best interest rule would apply in circumstances where the fiduciary would be able to enter into a transaction under the rules of one role, such as the beneficiary or the fiduciary of the corporation, but not under the other role, so that of a trustee. That would give the dual fiduciary the freedom and flexibility to make determinations that have massive implications for the business, whether without the fear of a court second guessing their determination. So, where would this new rule leave Sonny? So long as Sonny can say that he was put in a position where he had to balance the interest of the entity and his brother, kiddo, and as long as he exercised those three elements, he did his duty of care, he had good faith belief for doing so, and so, and as long as he did it with the care of an ordinary prudent person, he would be able to assert a defense in this derivative action. But regardless of Sonny's fate, as the ownership of closely held family business entities by trust become more common, we often anticipate that this intersection of trust law and business law will be the subject of a lot more litigation. As we try to figure out, whenever people hold these dual duties, as both a director of a corporation and a trustee of their parents' trust, we're going to be litigating this increasingly more as we try to figure out where we draw these lines and who acts appropriately and who doesn't. Okay. I know that was a lot to unload on you guys all at once. I'm sorry for that. But does anyone have any questions? Yeah.
Why do you think Kentucky has such little case law to this point? Because I mean, typically Kentucky has a higher number of family-owned corporations that qualify as small businesses than most other jurisdictions.
Well, I think in part because, like I said at the beginning, most of this case law is based on the Donahue rule. Right? So Kentucky, the basis from which they have to work is statutory, and I think it's a lot more. Trial courts make decisions, and appellate level courts, so your state court of appeals, just aren't eager to take those up yet. Because this is such a new area, it's really difficult for them to make up their mind about what they want to do. And Professor Warren may be able to talk about that.
Yeah, I think the first thing that strikes me about your article is that, or your presentation, is the incredibly difficult position that kind of succession plan puts Sonny in, right? And whether he can serve the dual role if his primary obligation as he's probably chair of the board, he's certainly on the board of directors, he's probably the CEO, as per his father's wishes. He controls 80% of the stock of the company by virtue of his own individual ownership and his position as trustee or titular holder of the stock. And his brother comes in and says, I want dividends all the time. You've also got 20% of the company owned by other family members who may be more or less in agreement with Sonny that we're all okay. The business needs to be fairly capital intensive for now because Dad has died and he renewed the business. Not a time for us to drain off cash when the company's in trouble due to leadership change. So so it seems like Sonny's primary job would be to protect the interests of the company. And in doing so, he tends to protect the interests of Sonny as a beneficiary of the trustee. On the other hand, if Sonny's out there with no job and no money and perhaps has the flu or something worse, that's the rub, right? Because then if I'm Sonny, I'm thinking, I can't really, what is the scope of my fiduciary? So you know your fiduciary, your trustee, but what is the scope of Sonny's fiduciary responsibility to Kiddo? If it's just if it's solely to hold that stock, then you can say, well, then the stock it represents the wealth of Kiddo, and by protecting the company, I'm protecting Kiddo's wealth.
Right.
Kiddo's going to be fierce, so well, you're protecting me. And I guess Sonny would say, through you as his lawyer perhaps, that no, the scope of my relationship does not include taking care of you and making sure you're happy. My relationship is intended by our father is to protect the asset, keep you from squandering.
Exactly.
So in that sense, he could probably succeed and render his dual fiduciary duty, the performance of his dual fiduciary duties, given the scope of his fiduciary duty in both roles, consistently.
Yeah, and I would say 97% of the time that would be true.
3% is going to litigation.
Yeah, and the difficulty comes whenever Kiddo makes the cousins mad, and they say, well, we've got our 20%, and Sonny's got his 40%. Together we have 60. So what we want to do is try to put the squeeze on Kiddo because he's caused us all these problems. He's wanting to.
Kiddo can't vote.
No, he can't. So, but Kiddo, it's a family operation. We can't just consider the legal status. There's also all these relationships, social relationships. Yeah. So legally, Kiddo may not be able to leverage very much, but in the personal lives of all the cousins, Kiddo can wreak havoc. So that the moments where the cousins look out at the landscape and say, in 10 years, this is going to be a huge problem for us, and as a fiduciary to the business, Sonny, you need to do something. And Sonny says, well, I can't. I'm also Kiddo's trustee. That's where the conflict really occurs.
If you guys are the lawyers representing Pop before his death, so you've been asked by Pop to write a succession plan. Again, it was never my area, but I would think that you would advise Pop, knowing that Pop is putting Sonny in a position of running the company, so he's going to be wearing all kinds of fiduciary hats as an officer, director, controlling shareholder, and a fiduciary hat, at least maintaining the share stock for his younger brother. Wouldn't it be wise, there are probably better methods, but wouldn't it be wise to say, all right, Dad, go ahead and name me trustee, but go ahead and name an independent successor trustee, like PNC Bank. Because if things start getting hot, I don't want to deal with that. I don't want to deal with that. And the bank will. And the bank will then decide whether its job is trustee, not of Kiddo. That's a big distinction, right? But of Kiddo's property. Then they can measure out what their performance, they'll determine what their scope is and what kind of performance they want to give in fulfilling whatever scope they determine they have. But it takes Sonny out, because in my view, Sonny's, that's what's, you maybe you went the other way on this in your presentation, but it seems to me if Sonny is representing the controlling person of this entire business, which involves 50 other people, that his probably primary duty is run the company and the shareholders collectively, and not to Kiddo. Yeah, and that,
whenever I mention the fact that the testator's intent is hugely important whenever courts consider the duty of the trustee, because the testator can waive a lot of those in their device. So in my brain, as I was working through this hypo, it made a lot of sense for me. Well, there's an implicit assumption in some courts. That's how far they've taken it. That if a trustee has made this person the dual fiduciary, that they implicitly waive that. That they recognize that it's conflict. Now, some courts require express waivers, so they have to say.
That's interesting. I know that there are, and it is a fascinating area. It's because it's so hard to find the underlying common law policies. Because I've always read scholars who've been studying. My counterparts, other schools have devoted their entire lives to this area. One of whom I know is Don Langford at Georgetown, who he would say that the testator can certainly limit the fiduciary responsibilities of the trustee he names, but he can't waive breaches of trust of fiduciary duty in advance,
right.
And he can't completely exculpate the trustee down the road. The common law represents an important public policy.
Yeah,
and it can't be overridden by a testator.
Right, and there are limits to what they can waive. So reckless behavior or behavior that is so clearly detrimental, they can't do that.
Yeah, and you go from jurisdiction to jurisdiction, and you'll find a line in different places as to how far a testator can go and eliminate fiduciary responsibilities, given the strong public policy underlying fiduciary duties generally. Because it's the strong helping the weak, it's the person with all the power having all the responsibility, which I thought was a very good part of your presentation. Because one of the underlying tenets of law in general is that the greater the responsibility, the greater the power, the greater the responsibility. It's sort of correlative.
And where this is a relatively, believe it or not, simple fact pattern for this issue. Oftentimes, Pop will appoint 3 trustees, all of which who still have an interest in his business. So he'll have, maybe his wife and his, whoever. There'll be 3 or 4 of them, and they're all disagreeing about everything, and nobody can decide what to do with the business. So it's completely gridlocked.
This same problem comes up in other contexts, including obviously the whole area of T&E, it's estate law, right? Because think about this person. Let's assume you have your mother or father very old, and they've got whatever the other spouse left them, and they know they're going to live forever, and they want to name you, since you're the lawyer, is the person representing the estate. But let's say you know in advance you've got some cantankerous siblings, and the siblings are married to some cantankerous people too. And if you're doing so if you put yourself in that position, and you sort of put your client in the same position, and think yourself there too, you might want to have a successor trustee named by your parent. Yeah. Because if it gets hot, you really don't. Life's too short for you to be in the middle of that. So you may say, I can resign at any time. So you go to the siblings and say, I don't need this seat. Life's too short. I'm going to resign and let PNC Bank take over, or some other institution, where they know that then they're dealing with the cold hard metal of objective metal, if you will, of an institution that really wants to do the most conservative things possible, and they don't negotiate much with the other siblings.
No, and I did kind of mention it, but I didn't really get the chance to highlight it because the social aspect of succession plans is just as important as the legal aspect. Because you've got your dad who clearly favors one son over the other, but has this, feels like he's responsible for the son who has another.
Most parents want to go that way, right?
Yeah. So Pops feels like he has to try to do something to protect the second child, even though there's not been much of an effort. So I can imagine there's tons of research on the interpersonal relationships in these kinds of
decisions. Social science research, and it probably is.
Yeah. Also, is the buyout option not acting in the best interest of Kiddo's portion and Kiddo's, I guess, trust?
Yeah, I mean, it definitely could be.
It sounds like that was written in by Pop, or at least.
Yeah, well, and that's exactly, there was I think it was for New Jersey in one of the cases where a trustee had the option, a trustee director had the option to buy the shares of the trust. And there was a question of whether or not, the reason why I got into litigation, there was a question or not about whether or not they had to declare dividends before they bought those shares. So it's a really interesting case basically about, well, did he have a fiduciary duty to do that because it was in the best interest of the trust, but it was in the bad interest of the corporation, right? So and that's the reason why I mentioned this fact pattern is because as for valuation, there's a really serious question about if you know that it's going to be valued today a lot less than it will be in 6 months. You have that duty to the trustee, to the corporation. What do you do?
Well, you could always, Pop before he dies could secure a respectable valuation from an appraisal firm and come up with a number that would sort of equate Kiddo and Sonny's inheritance, but with Sonny getting all the stock and Kiddo getting the cash.
I want to say in the case that I read, it was the parent valued it like $25 per share, and the sibling bought it for $50. So that it was clearly to the benefit of the trust whenever they bought it, which was really strange.
So in your example, Kiddo would come out pretty well.
Yeah.
Because still, if the kid's a spendthrift, you can put it in in an irrevocable or irrevocable trust that would run him out to his 40s before you get the money.
Yeah, and that honestly, that's why whenever courts are looking at these issues, they consider the financial situation of the beneficiary. Because if it is someone who's income dependent on this trust versus someone who, well, this is just kind of some money that they're going to have for spare change, spare.
And that's the area of trust law I've never delved into much, which means that you can be a trustee of property, but you can also be a trustee in the sense that you're sort of personal guardian, which carries with it a lot more weight. That clearly would put Sonny in direct conflict with other duties.
Yeah.
And that's what Pop needs to, or you're the larger Pop, you need to come up with devices. And I think there's room for a lot of creativity here.
Okay.
In sort of imagining, that's why your presentation is really good, imagining what the social dynamics will be and setting up a structure that is likely to avoid conflict going forward.
Yeah, I mean, and this is one of the reasons why I was really excited to talk about this, because there's so many pitfalls. So Pop could have made a plan where that Sonny got 100% of the business and Kiddo got 100% of his personal assets. But the problem is, assuming Pop was just flush with cash and houses and things, it would have been equal. The problem is, Kiddo's going to be able to squander that pretty quickly. And Pop probably knows that. But Pop doesn't have any other kids than Sonny. So, it's like, well, now I've given Sonny the business and also complete control over my personal assets, allegedly to the benefit of Kiddo. So they're really difficult questions.
But if Pop had left the 40% to Sonny and put Kiddo's 40% in a trust at PNC, then and PNC's responsibilities were limited to prudent management of the trust property, then they don't really have to pay a lot of attention to Kiddo going forward, unless the trust itself specified other duties for the trustee PNC to assume, which it probably might not.
Okay.
But again, it might, in which event you got a different outcome. But in any event, the bank shouldn't have a conflict with, they're not a controlling person of the company, so they're not going to have a conflict with the company itself.
Yeah, and really, I think that is where good lawyering comes in, because then you can convince your client that it's actually superior for them to go to the bank than it is for them to give the other party interest to their second child.
Yeah.
Right? So you really have to be an advocate in that situation to convince your client that is actually what's best for them and their interest and their kids' interest.
Right. You could also, I'm just making this up, right? You could also Pop could restructure, could recapitalize the corporation. And I know recapitalize is a big word, but doesn't necessarily have a big meaning. But by recapitalize, it means he could split his stock. He could reclassify, by many of the arguments, he could reclassify his own stock as Class A and Class B. And the Class A could have the voting rights, and that's what he leaves to Sonny. And leaves the remainder to Kiddo, but with no voting rights.
Right.
So the Kiddo isn't ganging up with the cousins on Sonny.
Right. Which would be disastrous in this situation
Right.
for the business. Do you have questions?
Yeah, I guess is the majority of these cases going, or I guess it'd be issues or who's getting sued, I guess is my question.
Yeah.
So how much of it's malpractice against the attorney that was doing the estate planning, and how much of it's allocated to the trustee issue?
Everything that I've seen is allocated to the trustee issue, about to whom the fiduciary duty was owed and whether or not they breached that duty by making some kind of a business decision. So there was one instance where the guy had left his wife as the beneficiary of the trust and appointed his longtime best friend and co-manager of the business as the director. Right? So the wife.
It's trustee.
Yeah, it's trustee. So the wife also sat on the board of directors for the corporation. So she's both the beneficiary of the trust, so gave her some portion of the shares, and she sits on the board of directors. And the manager guy votes on the board too, because he moved up. So the wife wanted to do just what Kiddo wanted to do. She wanted to get more money. So she, as on the board, she pushed the board to get more dividends. Well, the old friend said, no, we're not going to do that. We need to keep capital in the company because we have all these plans. We're not going to take that risk right now. So she sued him because he refused to issue dividends. Said he had a duty under the trust to make sure that she was able to pay for whatever it was she was wanting. I can't remember. And he breached that because that trustee duty, fiduciary duty is so high. She was elderly. That was one of those situations where there was more than just management of the property. It was also management of her as an elderly woman.
Right.
So she sued under that principle. Rather, and the court said, well, like, what do we do? He had to exercise his business judgment in deciding not to issue these dividends.
Wearing the other hat.
Wearing the other hat. Are we supposed to hold him responsible for violating the fiduciary duty of the trust or for violating the fiduciary duty of the business? And that's where these people are faced with really complicated decisions. And that's why, more or less, I say there should be a presumption of the lower standard unless it's rebutted. I know that was a long answer.
Well, no, but he gets business judgment rule protection in his role as a corporate fiduciary, but he doesn't necessarily in his role as a trustee of the property and of the income trust. So presumably the income trust, and not only does the trust hold the property, it holds some performance responsibilities in terms of whatever income comes from those shares, it gets distributed to Kiddo in accordance with his needs going forward. And I don't know how banks do that. And it's obviously they have standards that are established in terms of how they. And this happens every day, right? People get left fairly decent-sized estates to a surviving spouse, and she might live 50 years, and of course, the kids and the stepkids and everybody else would like to have the money now, so they're hoping she dies. It's pretty gruesome. And at some point, is the remainder beneficiaries, they may be angry with the bank,
Right.
and you end up with litigation about the bank overpaying the widow or widower during this period of time. So standards have to emerge. So if you do get in litigation, you're going to need to bring in people who serve as trustees of these kind of trusts as experts on what the standard of care is. Because they're not going, no matter what it looks like, the court is always going to be faced with, all right, was there fiduciary duty? If so, what was the scope of that fiduciary duty? And third, did the fiduciary act in accordance with the standards of the profession? Which is why you bring in an expert who's going to say, right on blackboard, here's what those standards are, and I've reviewed the facts, and in my view, without reaching an ultimate conclusion, is that this party, this trustee acted in accordance with the applicable standards of care. And then you've got resolution, presumably. And I've seen trustees who are actually business trustees brought in as experts, but very often lawyers are brought in as experts. And I've explained this recently in our business arts class. They're brought in because lawyers are the ones that tell trustees what their fiduciary duties are. Now, trustees in turn have to develop practices, but the lawyer may also inform those best practices as part of his or her responsibility in advising the client.
Yeah, and the corporate documents also can set out the duties of directors.
But not the standards of care against which breach of those duties will be measured. Now that law school is super confused about it.
Yeah.
See, in law school you learn all these duties, and you don't know anything about standards. Now obviously, if a building collapses, we know the architect had a duty of care to, that's the duty, and there might even be not only common law, but statutory form of that duty. But when he is alleged to have breached it, somebody has to talk about what are the standards of care of an architect. So we obviously don't learn that in law school.
Right.
But we do learn, we should be learning what the standards of care are of directors, because we're the ones that advise directors as to what they ought to do. Attend board meetings, read the stuff. Don't ignore corporate hemorrhages when you show up those 4 times a year. Read the minute book. So we do help set standards for fiduciaries in general. We certainly set standards for other lawyers. We all know that. We set standards for fiduciaries to some degree, but we don't set standards for medical doctors or architects. But remember, standards are critical because it's one thing to allege duty, breach, damages. When you're talking about breach and causation, when you're talking about breach, you got to establish that here are the standards in this context, and here's what he or she did.
Right.
And if there's a substantial departure from those standards, then we call that negligence. If there's a reckless departure, we call that gross negligence, which can allow punitive damage. Any other questions, class? Very good job.
Thanks for
Okay, class, next time we have Greg Jones who's going to talk to us. He literally can go the full 2 hours. I told you he always was here for just like these other presenters for 45 minutes, and then he would stay and listen to his presentation for the last 45 minutes. And he somehow forgot, because one time he shows up and says, "You mean I only have an hour?" I said, "Well, sorry, Greg, next time I'll arrange for you to have the whole class." So he wants the whole class, and he'll use those. So hopefully he'll stop in time for you guys to ask some questions. But he really created this pharmaceutical company from scratch after having won the first vote award. Our battery guy won the vote award. I think now they spread it out among 5 or 10 recipients. But he won the first one, and way back, I guess 20 years ago, and I guess it's 15, 20 years ago. And he'll tell you more about it. After he got the award, the very famous research doctor from Europe working with him disappeared. Just disappeared off the face. They never found him. He went back to Europe. He didn't die, but he just didn't show up again. So Brett said, "Well, I guess I should go return the vote award." So he went back and tried to give it back to him, and they said, "We're not going to accept it. You're going to have to figure it out." And so he's continued building his company since that time. So I think it'll be very interesting. All right, we'll go early today. I'll see you next week. Would you send a copy of your slides?
Oh.
I think I can put it on Blackboard.
Okay, is that how you do it? Because I was going to ask you how you're going to do it. I didn't know how to
That's
find
fine.
it.
Yeah. Send me a hard copy by email.
Roster out there on Blackboard? Oh,
Yeah, from Blackboard.
okay.
You know, we'll pass that way.
Because that's to do it. All right, thank you.
Did everybody check the?
Here's more. I'll wait for this one. TG. The coolest person all the time. How was you on Auburn? Was it fun? It's insane.
That sounds fun too, though.
It's fun. It's fun. I was going to say 5 years. A little bit.
Yeah.
I'm sure. Yeah, it was fun. It was fun. And we were getting basketball and football at the time, so it's cool. Hey, how you? Not well. We kind of just got out. You got class? I like this watch.
Thank you.
No, definitely not the rain.
So like before I heard, this was a while ago, I heard that you thought that because like consolidated in the that was never the case. And I should have figured it out, but I didn't, and it wasn't because like I was upset with you or anything. It was just like I was overwhelmed because I was
Dude,
taking my credits.
you don't have to explain anything.
No, but
Yours
like-
was fine.
But
I
like,
said,
just like, I heard everything's for money.
no, for me.
You should do the taxes as a thing.
Oh, that's fine.
Yeah, I mean,
For
so,
me, I was just like, you said you're overwhelmed. I understood that. I'm like, you did it the right way. I told pretty much everybody that. I don't think I told anybody else. But the other one, I was like, the first time. And I wasn't great for emails and money, but
I mean,
still.
yeah, but like, so I wanted to talk about it for a really long time.
Don't worry about me.
But I never did. So
I'm
now
fine.
it's like, okay, well, maybe that's
Ah, yeah. I
It's
hope
like,
you're doing great.
You and I were friends, and we never talked to me. So I didn't know. Like, just maybe you know something. Because like, I see your name, and it's like, I feel like,
Don't do it.
I'm awkward, and like, oh, I really think you were in. It's like, oh, I promise you, but it's like, different service. Like, looking like I really different, but it wasn't the case. It's like, it was like abroad, and
I know what you're saying.
And so, I mean, I think that if anything, like, she told me that she didn't want to talk to me anymore, among other things.
that's
And so,
really-
yeah. And so, like,
okay.
I know that she.
See you later.
Hey.
Yeah, this is-
Thanks for what you do right now. These things. So then, so I heard it from one, well, one, I'll be there for like to hear everybody who just to like run and
Yeah.
vote.
But no, don't worry about it. And I feel bad that you made you feel bad.
Well,
That's
it was just like,
I just feel bad. I got so many people I got to
Yeah,
apologize to, really. So.
I was just kind of like on him, like I always thought that I should have like talked to you about it because I planned it like that, and I was just like, it wasn't even because like I didn't do it because I was like, she's doing it, so I'm not doing it
Yeah,
anymore.
yeah,
It was more like,
Don't worry. We're
I
completely
feel
fine.
like everything I could legit. So,
All right. Well, here, go ahead and get the question. Great job, man. Dude. All right, dude. You killed it. Like, I like the hypothetical thing. That was nice.
Well, there are like 4 areas in the fiduciary
Are you coming this way or no?
No, that won't be perfect.
Oh, well.
So I'll just pick one.
Okay.
And that was my pick.
I like how you did it and then it kept us a little, awake more.
Yeah.
than-
Yeah.